Good afternoon, ladies and gentlemen, to the meeting of the Canyon City Planning Commission. My name is Gregory Carlson, and I notice that we currently do not have a chairperson and a vice chairperson. Therefore, under our bylaws, under Article A, Action 4, I'd like to put my name forward to be the chairperson pro tem until we can nominate a new chair and vice chair. Is there any objection? No. Hearing no objection, the first order of business is the roll call.
Certainly. Good evening. Commissioner Maloney?
Here.
Commissioner Ledoux?
Here.
Commissioner Carlson?
Here.
Commissioner Bellantoni?
Present.
All right, will you please join us in the Pledge of Allegiance? Thank you very much. The next item on the agenda is the nomination for chairman and vice chairman of the Planning Commission. I now open the floor for nominations for chairman. Are there any nominations?
Mr. Chair, I'm confused. I'd like to nominate Angela Bellantoni for chairman.
Is there a second?
Second.
All right. Commissioner Bellantoni has been placed in nomination for chairman. Are there any other nominations? Hearing none, the chair entertains a motion to close nominations.
Oh, I'd like to move we close nominations for chairman.
There's been made a motion to close nominations for chairman of the Planning Commission. Is there a second?
I'll second.
Would you like to please take the roll only to close nominations?
Commissioner Maloney?
Aye.
Commissioner Ledoux?
Aye.
Commissioner Carlson?
Aye.
And Commissioner Bellantoni?
Aye. Can I? I don't know.
Nominations are now closed, and so therefore we have elected Commissioner Bellantoni chair by acclamation. Congratulations.
Congratulations. Good evening. I don't like this seat. Okay, so I now open the floor for nominations for vice chair. Are there any nominations for vice chair?
Madam Chair, I'd like to nominate Commissioner Gerald Maloney for vice chair.
Second?
I'll second.
Okay. Are there any further nominations? Okay.
Madam Chair, I'd like to move that nominations for vice chair be closed.
Is there a second?
Second.
Okay. Then by acclamation, Commissioner Maloney will serve as vice chair for the term expiring June 30th, 2017. Okay, so now we will now move on to a normal meeting, which is approval of the minutes of a regular meetings of the Canyon City Planning Commission held on August 16th, 2016, our regular meeting. Are there any corrections? Hearing none, I need a motion and a second to approve the minutes.
I'd like to move that we approve the minutes for the August 16th meeting.
Second.
Thank you. I hear a motion and a second. Denise, will you call roll, please?
Certainly. Commissioner Carlson?
Aye.
Commissioner Maloney?
Aye.
Commissioner Ledoux?
Aye.
Chairman Bellantoni.
Aye. I now ask for approval of the minutes for Canyon City Planning Commission held on September 20th, 2016. Are there any corrections? Hearing none, do I hear a motion and a second to approve the minutes?
I'd like to move we approve the minutes from the Tuesday, September 20th, 2016 meeting.
Second.
Denise, will you call roll?
Certainly. Commissioner Maloney,
Aye.
Commissioner Carlson,
Aye.
Commissioner Ledoux,
Aye.
Chairman Bellantoni.
Aye. Thank you. Okay, we will now move on to item 5 of our agenda, which is a public hearing to consider the adoption of amendments to Title 17 zoning regulations of the City of Canyon City, more particularly to revise Section 17-20-085, which is food carts and kiosks, and Section 17-08, which are definitions. I'd like at this time to open the public hearing. The provisions of the City Municipal Code and the particular Title 17 thereof, the subdivision regulations, and the comprehensive plan of the City of Canyon City are incorporated into the record of the hearing as if set forth verbatim. Please may we have a staff report from the city planner.
Yes, Chairman Bellantoni and members of the commission. Excuse me, this is a zone code amendment for Title 17 to repeal and to reenact Chapter 1720.085 for food carts and kiosks, and also to revise Chapter 1708, the definition of food carts and kiosks. Public notice was published at least 15 days prior to the first public hearing, as was required by law. The application was tabled at the August 16th, 2016 meeting, as there were legal questions that the zoning administrator, also the city administrator, wanted to have answered. And so that meeting was postponed until the next regular meeting, which was September 20th. Unfortunately, at that meeting, we did not have a quorum. We are now meeting, and we'll discuss the revisions to the food carts. We met on 2 separate occasions with the food truck community in an effort to revise the regulations so that the food trucks can operate more freely within the community once they have obtained a permit. These revisions reflect a somewhat different process and more flexibility for the location of food trucks, but they still maintain all of the health and safety standards and standards that will protect the general public. I'm going to go back and give you just a little bit of history. Food carts were originally established as a conditional use permit. That's a staff level permit that allows any number of different kinds of uses that are in between something that might be a permitted use and something that might be a special review use, which is, as we know, the highest level of review. It's approved at the staff level. Food carts were put into that basket, and yet they don't fit very well. For instance, on a conditional use permit, you would ask for a specific location. You would apply for a permit. You would pay $100. It would be a staff-approved review. You would provide a site plan. You would, like I said, you would have a location. We would send a notice to adjacent property owners. It would take at least a month to approve that, and you would have one place where you could locate on a regular or semi-regular basis. That seemed to be somewhat onerous. It didn't allow food trucks to really move around. In 2014, the planning staff decided to put forth a revision to this and created something called a temporary use permit. Very different. It was still staff approved. You could locate up to 3 locations. The fee was cut in half, and it appeared to, it alleviated some of the concerns of the food truck community, but not all of them. And when our current city administrator came on board, we decided to start talking to the community, and the food truck community wanted to talk to us about that again. So I'm going to go through what those changes are. They still, this establishes a framework where they will be able to locate, once they have their permit, they can locate, as long as they follow the particular framework, they can locate anywhere they want in the CBD, central business, the commercial, or the industrial district. And then they also have a few locations that they can go to in a residential district. They still have to provide a CDPHE food vendor's license that they get from the county. They also have to provide liability insurance. And then also a permit that we approve. So I'm going to go through, rather than going through the highlights and that kind of thing, and I'm going to go through the changes. If you'd like to join me on the red line. This pertains in Section A as a standalone food cart that can be set up in the commercial, central business, or I zone, or other locations that we have now specified. These are the regulations. Item number 1, the food truck has to have a CDPHE license, which again, I said they get from the county. They have to have a sales tax license up to date at all times. Number 3, they have to have general liability insurance coverage. All of these things were established previously. We did add some other language, as you can see at the end of number 3, that if they cancel or reduce their coverage, their permit becomes void. In number 4, they have to display their permit. Number 5, they can't obstruct a parking lot where they're located. This was in the original. This was in the original regulations as well. They can't infringe upon the ability of pedestrians to negotiate the sidewalks. That's number 6. That was also in the original. Number 7, they have to be at least 100 feet away from any eating and drinking establishment. And we did change this somewhat, that is open for business unless written permission is granted by that establishment that's within that distance. That was something that we had initiated kind of as a policy earlier, not that if they were open for business, but if, for instance, I can give you an example, at the Cup and Cone, there used to be a little hot dog stand, and they wanted to locate in that little plaza area outside the Cup and Cone, except that the Cup and Cone was within 100 feet would have been within 100 feet of their cart. They went and got a written permission from the owner of the Cup and Cone, and we allowed them to locate within that 100-foot distance. Number 8, they have to have written permission from any place where they are on private property. That is not new. That was in the original. They have to keep, number 9, they have to keep their food carts and that area clear of any litter and properly cleaned. That was in the original. We've changed the signs just a little bit. They can have, their sign can be illuminated now, and they can use a menu or sandwich board advertisement as long as it doesn't impede pedestrians or traffic. That's new. They couldn't use that before. They could only have that one sign, a sign on their truck. Number 11 hasn't changed at all, meaning that they can't put anything out that, again, is going to infringe on the ability of pedestrians to use a sidewalk. This is a different one that was disallowed in the original and even in the 2014 revised. Food carts and trucks may locate on the same lot or parcel so long as they each have the property owner's permission. This would not, the original would not allow them to co-locate, which we didn't quite understand, and they certainly wanted this, and the staff agreed. We added number 14 so that we were concerned, we didn't think that it would be appropriate for food carts or trucks to be stored in a right-of-way in any way, so they have to be stored on private property. 15 talks about all of the requirements with respect to locating in a right-of-way. Their merchandise has to be offered, displayed, and sold, and people served only from the sidewalk. That's item A. Item B, you can't put a motorized, like a food truck, on a sidewalk. We wanted to make that clear. Carts and trucks have to be at least 25 feet from an intersection. That's item C. Item D is an error that should have been stricken. That was in the original revision, and there was I would say a staff disagreement about that, but it was permission that is once given by the city shouldn't be removed necessarily by someone, a private party. So we've given them permission to locate in the right-of-way, and they should not necessarily, there wasn't a good rationale for having them get adjacent property owner permission. In the CB district, we have so much angled parking, and a food truck cannot locate in angled parking and serve, because that means they can't serve it and be parked legally, because otherwise they'd be serving in the street. So the central business district between 2nd and 8th doesn't have any parallel parking. There's no place for them to park. So we're being a little bit redundant, but we've told them that they can't locate on Main Street between 2nd and 8th, but they can locate on side number streets as long as they can park legally, if there is a place for them to park. A lot of the side numbered streets also have angled parking, but there is some parallel parking there too. So that allows them to be in the central business district and still park legally. F, they have to comply with all traffic and parking ordinances. And G is the last one, that they cannot they can't cater private events from either the sidewalk or the right-of-way without an approved street closure permit. Now, they can do it if they can also serve the public and park legally. So that takes care of rights-of-way. Item number 16, and this is generally they are not allowed in residential districts. And they wanted to be able to, and we felt that it was appropriate, that there are any numerous school events and rec district events where it would be appropriate for them to be. So we loosened it up such that they can locate in residential districts in rights-of-way adjacent to school district property and rec district property, and also city park property. And they can be on school district property or rec district property if they have permission. And that goes back to item number 8, which says that they have to have permission, written permission to be on private property. This is something else that was unclear, and we've tried to clarify it in these regulations. And also in item number 16, there's no permit required for a one-time private catered event that's occurring on private property. So if you're having a party at your house and you would like to have a food truck there to serve your guests, they can do that if they're located on your property, like in your driveway, but they can't do it from the street. So there's no private service from a public right-of-way. In the last two, 17 and 18, food trucks can be allowed in city parks and plazas. All of that information, all of those permit requests are going to be kind of a one-stop shop coming to the planning department. The Parks Department will review it and allow it however the Parks Director wishes to do that, but those permits will be run all through the Planning Department, and I probably will be the point person for that. Item B is the same as it was before. C and D simply are reiterating what was stated above. Just wanted to make sure that everyone understood that. As far as the definition goes, the definition actually originally allowed the sale of retail goods and other merchandise. Because we're opening this up to various and sundry locations, in numerous locations in the city, it was felt that it was appropriate not to allow other merchandise. This is strictly for the vending of food and drink. And we also changed kiosk to truck because it's a more common and understood definition. A kiosk is certainly still defined as something that can, be used, but a food cart and truck seems to make more sense in the terminology used today. And finally, if you'll go to the last page, which is something called the food trucks at the market parcel, has a photograph on it. The Parks Director and I put our heads together and came up with an area that might be appropriate for food trucks. It has not entirely been established yet because there's some bit of landscaping that needs to happen. There's some power poles that need to get some boulders put around it so people aren't accidentally run into it. Anyway, this particular area is right on the river. It's just to the east of the ice plant and just to the south of the overflow parking for the train. It's the yellow highlighted area. It was originally established, my understanding from the Parks Director, it was originally established to support the farmers market. They decided they didn't want to have that location, and it's since been pretty much unused. And so the Parks Director decided that this could be an okay place for them to locate. And they wouldn't need special permission to do that. As soon as this is ready, we'll let all of the food trucks know that it's ready for them to come in, and we have a few safety precautions that we wanted them to follow so that they don't go off into the drink or run into the big tree that's out there and that kind of thing. So we hope that this is something that they can use and prosper. And I'd be happy to answer any questions. I will point out also, I gave you an email, a copy of an email that I received from the proprietor of Kona Ice this morning. She wanted me to pass this information on to you, that she's very happy with these revisions and supports that. And there is at least one other, there is. B&B Smokehouse proprietor is here too, and may have comments also about these revisions.
Okay, thank you, Ms. Bernath. Are there any questions for our city planner at this point? Carlson.
Thank you. So you said that item number 15, Part D, was not meant to be in this draft?
Yes, that should have been stricken.
Can you give me an example of, like a hypothetical of what that would apply to?
Yes.
That's a tricky
Something
question.
may have occurred, let's say you have a business and there's parking out in front of your business, and a food truck comes and decides they want to set up there for I don't know, the lunch hour. And originally, this would have allowed that business to give their permission for that food truck to set up there. That has been taken away. So if they find a legal place to park and it's in a commercial district, they can set up.
But Part D takes that away from them.
No, Part D actually gives that to them.
So, for example, my building, 1107 Main Street, a food truck could park, parallel park, in front of my business without my permission. Is there a duration to that park, for them to be parked there? Or could they be parked there in perpetuity, or is there a limit to the time that they could be
Well, they
parked there?
can't store their vehicle there, but if, let's say, for instance, we did not establish any timeframes in here. Some jurisdictions do that. We did not establish any timeframes, so they could be there for as little as an hour, or they could be there all day.
And could they park there for consecutive days
Yes.
without moving?
No, they would have to move. They could not store their vehicle there, so it would have to move every day and be stored away, and then it could come back out. And
There's your example, Commissioner.
Okay.
Any other, did you have more?
I had one other
Okay,
question, though.
sorry to
separate.
interrupt.
So one of the big differences that these new changes are co-locating, correct? Because before there was only 3 places you could go, and
Right.
that had to be written out in the permit.
Right.
My question is, what is the potential conflict resolution if you have 2 vendors who feel like they both deserve that spot, and they feel like they both have and they do both have the right to use the same spot? What is the avenue for them to go through to resolve that conflict?
not the city. I would consider that a private matter between them and the property owner, if they're going to be locating on a piece of private property.
What about a piece of public property, like, for example, the example we had right here?
Well, again, that's going to be something probably first come, first served. We could certainly put that in there.
Okay, I think it's worth bringing up because I think the probability of that happening is more likely if people don't have to specify in writing where they are to be
Sure.
located. So with greater flexibility, I think, is the greater chance of potential conflict. I would hope that they would resolve it privately, but that's why I was just asking what would be the avenue for resolving that conflict if it were to come up.
We actually did not anticipate that. And truthfully, I would say, I would hope that we don't have those kinds of problems, that community is going to have to work out their differences. And I would imagine at this point they can.
Thank you.
Okay, any other questions from the commission? May I ask 2?
Of course.
Thank you. So as I understand this, the intent is for the truck to park parallel, in a parallel parking spot, or
Yes.
in a park that way, correct? Correct.
Yes.
Okay, so, and it states that the parallel parking space must be more than 25 feet from an intersection. And that makes good sense for vision,
Yes.
for
And that's why
traffic.
yes.
So how about driveways that are in the central business district as well? They can block the vision of people driving through driveways. Driveways with curb cuts in the central business district.
Well, we could certainly add something that addresses that, and I'll talk to the city engineer about that. It probably wouldn't be 25 feet from, but it could be 15 or so.
I could see
I
where
could
a
re-
food
we
truck
could-
would block the vision
Could.
of
It could very
cars
well.
leaving a parking lot.
I will look into that, and we can add that.
Just a thought.
No,
One more. So back to 16, no permit is required for a one-time private catered event occurring on private property, right? We just,
Yes.
okay. One time ever in the life of that property owner?
No.
One time a year? One time what? I mean, this is kind of very close to a garage sale. Our restriction is 4 garage sales in 1 year, is that correct? Something like that?
3.
3? Okay. So you said one time private, one time ever in your life? One time what?
Non-recurring.
That's
Ever? I can
No,
only have one graduation party in my house with the catered truck when I have 6 children. Do you hear what is this making sense?
I do understand what you're saying. We didn't really want to limit it in that way, and I like Jerry's term of non-recurring. The idea was that it was a one-time event, a one-time party, and then a month or 2 later, you could have a one-time reunion, and then you could
I think
have
Oh,
another.
you'd have to establish that it was recurring before you could not call it a one-time event. So if it was a one-time event once a week, that would be that would be recurring.
Right.
So you can't stipulate how many times someone wants to have a caterer at their house.
Oh, I agree. I agree. That's what I'm saying. When it
Do you
says a
think that-
one-time private event, I'm wondering if we need some
Okay.
clarification there.
Might you suggest some other wording?
What are you thinking?
I think until it becomes an issue, it's worded fine.
Okay.
How could it become an issue?
Someone might have a one-time event and think that that's the only time they could ever have it, ever.
Oh.
Ever?
Now,
ever.
I
more
see.
than
So you're
likely-
going with the positive, not the negative.
Yeah, well,
You're
more
right.
than
I'm going
likely,
with the
we would.
positive. I'm going, let's just go down a path of a child's getting married, so I'm going to have one of these on my property. So it goes well, and 3 years from now, from that point, it went so well, I want to do it again with a graduation from college, but oh no, I can't have it. I've had my one-time private. Based on the way it's written, based on the time it's written, the way it's written, one-time private catered event. So how are we, I mean, I understand, where you're flipping, you're going the other way, I'm going this way, aren't we, on this? Yeah, so just a thought.
Maybe we wouldn't say one time. I would perhaps say a catered event.
For a private catered event
On private property.
on private property.
We could do that. If that would remove the stipulation or perceived stipulation of
But does
once
that,
and never again.
does that work with your recurring? Or do you say don't deal with recurring, like we're not going to deal with carts that want to locate in the exact same spot until it comes up?
I think it's understood what that sentence means, but I can see what you're saying.
If we just leave it to no permit is required for a private catered event on a private property.
You could add an additional sentence that doesn't allow the reoccurring. Like if you take out the words one time and then add an additional sentence that says, so that you don't abuse the privilege and take advantage of your neighbors or make it seem like it's public or something. You take out the one time and then add an additional sentence that says, however, you're not allowed back to back, or however you want to phrase it, reoccurring.
Use the word recurring.
Yeah, say something like, reoccurring events are not allowed under this use on private property. Even then, how do you define reoccurring then? I don't know.
Yeah.
Kind of getting in the weeds a
I
little
think
bit.
we may go the same way. I'm happy to take out one time. I'm going to suggest that unless and until we have an issue with that, let that stand for now.
I think that there's a definition here that helps with a lot of this. With the one time gone, private parties, reunions, weddings, and the like that are on
That's
private
true.
property. So I think the one time, it's just one time. If that's eliminated, the rest of this, I think, would probably, suffice.
That work for everybody? And then we have to strike the one time down in C as well, C2.
Got it?
Okay. All right, so,
No.
any other questions for staff at this time? Okay, thank you. Are there any comments from the audience? Thank you. Good, we have community intervention. Thank you, intervention. Yeah, we need it. Would you please state your name and the address for the record, please?
Yes, I'm Roger Hendreski. My wife and I, Nancy, own B&B Smokehouse. We reside in Florence, 215 East 2nd Street. And we worked with city manager, with Terry, on these corrections or changes to the rules the city's had. I came from a environment, we moved here from Denver. Operated a food truck in Denver for many years. To the one question, food trucks fighting about a location, I've never seen it. And there's over 300 food trucks in Denver. And they need more. The food truck phenomenon is growing. We prefer to work in 2 or 3 or 4 food trucks together because people like to have a choice of their food product. And if we have more than 2 trucks at a location, that draws more people. So the parking that's being allowed down in a parking lot just south of here could enhance that as long as we have, we get the word out. We're there on a certain day at a certain time or a certain evening, maybe one evening a month or something like that, where we have a food truck rodeo or something like that. But the city has stepped forward and made a lot of good corrections. And this is something I think that we can live with. Sure, there's going to be changes, I'm sure, in the future. We'll come crying to Terry. But we appreciate the fact that you're looking at this, and we sincerely hope that you will approve it. Thank you.
Thank you for your comments. Anybody else?
Hi, John Hamrick, 108 Dewey Road, across from the high school. Just so you know, 108 Dewey Street gets all of our pizzas. But just one comment on the proposed regulations is that in the current regulations, in section 17.12 district and general regulations, there are 3 places where the food truck and kiosk language, which will be made obsolete by this new regulation, appears and will need to be adjusted. So 17.12.130, 17.12.140, 17.12.150 have the food truck and kiosk in it. That'll, to be conforming, it just needs some wording.
Thank you.
These are titles that I have made note of.
Okay.
Mr. Hamrick
Thank you.
alerted me to that. His eagle eye caught it.
Okay. Roger, you had another comment?
The thing with the 25-foot parking from a driveway or a corner or something like this, if you look at a food truck that's parked parallel, and you look at an F-250 pickup that's parked parallel, the vision is the same at both of those. A big pickup takes up more space, or as much space as a food truck, with the same width. Sometimes the same height if they have a camper on them. So think about it. Can we prohibit a food truck from parking at a location when we allow a camper to possibly park at that location? Just a consideration to think about.
Thank you for your comments. Right. Does staff have any further comments based on input from the audience
I have no further comments.
and staff? Okay. Are there any additional from the commission? Okay,
Quick question, just, do we need to make formal motions to make amendments to the language you've given us? Like, for example, make a motion to strike the words "one time"?
You can do that, or you can do them in bulk and say that the amendments that were discussed.
Okay.
I would like to ask a question, though, about, do you want us to consider still, after the gentleman's comments about big pickup trucks versus food trucks, whether that there should be some sort of distance from curb cuts and driveways? Do you still think that that's reasonable?
I do. I have one, and he said campers. And I understand that, and it is difficult. That doesn't make it easy just because it's the same. So I would concede, if you're not going to do the 25-foot, a 15-foot would be helpful. I was checking to see if Councilman Gill had a question.
The difference between a pickup with a camper on it and a food truck is that the food truck has people, it has activity. It has people coming up to the window, it has people standing there talking and visiting, which might maybe be more of a distraction than a pickup with a camper sitting there, you know, as far as people pulling out into traffic. I mean, it's just an observation, just a thought on my part.
A good observation. Yep.
Yeah.
So to Commissioner Carlson's question about making the motion, our two issues are, one, striking one time in two places, and two, including an additional setback from a driveway curb cut of 15 feet, but that would be the two. And do we put those in, go ahead, Commissioner Ledoux.
Can we eliminate the 15-foot driveway issue with permission of the property owner? I mean,
Well,
allow that as an option.
No, because we already struck that part about they can park without, in a right-of-way, because it is the street. We already struck that part, right?
But if
Yes,
we're
that's
going to
already been
add-
stricken.
If we're going to add an additional, regulation, why not allow the property owner that owns the driveway to exempt that part?
I would hesitate to do that because I think and when Angela brought that up to begin with as a safety issue, wouldn't want that necessarily to be the burden of the property owner.
To the point of we've decided that's a parking spot. It can be taken up by an RV or whatever. That parking spot can be occupied and it is safe to do so.
Well, if
Whether
it,
it's a-
absolutely, I would say if it's a legal parking spot, that it's a marked parking spot, then I would say that the distance requirement wouldn't apply from my perspective. If it's a legal parking spot, they can park in any legal parking spot. If that doesn't exist, though, there might be a curb cut and it's just blank. There wouldn't necessarily be any marked parking. In that case, they should probably be 15 feet back.
Oh, I'm talking about, there's parking
Anything.
spots all up and
Okay.
down Main Street,
All right.
parallel. And we often forget about 8th Street to 15th Street, which is all parallel parking. Okay, and there are curb cuts through there. And I think we need to, where there isn't good line of sight, especially near the junior high. Yeah, where
Just
that,
another observation, 15 feet is the length of a Ford Escort. We're not talking about a major,
We're not
a
eliminating
94-foot
anything.
from a cut. We're not, all we're doing is, I think that what's intended is to just allow the people that are maybe coming out of that curb cut to be able to come out and get out a little bit and be able to see both ways to pull out safely. But like I said, that's 15 feet that's the length of two couches. That's not a whole lot of room. But it's something I think that just as an observation may create some more of a little safety area there for people to go in and go out of.
okay, so,
We'll craft that and add that as a as a suggestion from the Planning Commission going forward then.
Okay, so again, to Commissioner Carlson's question, does this go under findings or does this go under motion? This would go under the motion.
Well, my guess is that it would go under the second motion, approval
motion.
of the zoning ordinance with the
With these
modifications.
changes.
It would be under your second motion.
Yeah,
And
okay.
you can be specific, or you can simply refer to the amendments that were discussed, as you
Okay.
prefer.
You know what I really like is that we're preparing to make a motion with an amendment and some changes. Isn't that exciting? This is-
Yes.
Yes. Okay, so at this point, are there any further comments or questions prior to closing the public hearing? Okay, hearing none, I close the public hearing. Is there any further discussion among the commission? I guess we just did that, didn't we? Sorry. I'll look at my cheat sheet earlier next time. Okay. Okay, I now call for a motion for our findings. Commissioner Carlson.
Madam Chair, I'd like to move that the Canyon City Planning Commission, upon conducting a public hearing on the above captioned zoning ordinance, that being repeal and reenact Chapter 172085 and revise 1708 of the zoning regulations, Title 17, and after considering the testimony presented by city staff and other interested parties, that we find as follows: notice of the public hearing was properly given as required by law.
And number 2.
And number 2, that based upon the findings of the above fact, that the Canyon City Planning Commission hereby makes the following recommendations to the council of the city of Canyon City.
Wait.
No.
No, I'm sorry. I meant number 2 under section 1. That you're actually finding if you do.
Oh,
that
I'm
the-
sorry.
That's right.
I didn't see the X there as well. And that the proposed amendments are necessary and appropriate.
Let me stop you right there. I'm not going to ever put an X in there. That you may find that they are not necessary and appropriate. So that's left for your discretion.
Understood.
When you
Thank
make
you.
that motion, sure.
Do I hear a second?
I'll second.
Thank you. We call roll? Please call roll.
Commissioner Carlson,
Aye.
Commissioner Maloney,
Aye.
Chairman Bellantoni,
Aye.
Commissioner Ledoux.
Aye.
Okay, now do I call for a motion? For approval? Okay, Commissioner Carlson, thank you.
You're going to let me have all the fun. I'll do it. Based upon, Madam Chair and Commission, I'd like to move that based upon the above findings of fact, that the Canyon City Planning Commission hereby makes the following recommendations to the council of the city of Canyon City. Approval of the amendment to the zoning ordinance, but with the modifications that we discussed in the hearing, including but not limited to the 15 feet and the removing the one-time use, including but not limited to those remarks.
Do I hear a second?
Second?
Thank you. Denise, will you please call roll?
Certainly. Commissioner Carlson,
Aye.
Commissioner Ledoux,
Aye.
Chairman Bellantoni,
Aye.
and Commissioner Maloney.
Aye.
Do we have any other topics to discuss?
I have a couple of things.
You're not on my agenda.
Just a couple of notes. I provided the bylaws to you this evening.
Yes,
It would appear that we may very well not have legal counsel any longer, and so here at these meetings. And so we're all going to be kind of learning our way through this process. I know we've leaned on our attorney, John Havens, for many, many things. And Planning Commission is not going to be one of his duties any longer. So I gave you the bylaws. I would also like to say that the council last evening appointed 3 new members to the Planning Commission. They will be joining us in November. They are John Hamrick, who is here with us this evening, Pat Frieda, and Ron Bates. So we will make them welcome next month.
Thank you, and I'm sure I speak for all of us on the commission as we will miss Mr. Havens. I have sat next to him since the day I started. I wish him well And also thank you to Ron Bates, Pat Frieda, and John Hamrick for coming forward, volunteering to participate. We look forward to you participating in the commission. Okay. Any other topics while we're having a free, open floor? Okay. Hearing none, I call to adjourn the meeting.